Plead guilty.
Shut up, Charlie. I got an angle.
What angle?
Him.
State your name for the record.
While it is very unlikely that the articles of impeachment filed by 11 congressmen led by North Carolina Representative Mark Meadows and Ohio Representative Jim Jordan will garner support from the majority of the go-along-to-get-along Republicans.
What I've heard is Jim Jordan wants to just take attention away from the scrutiny that he is under in Ohio. That could be part of it. The fact that truth and fact and data and evidence have never been something that the Republicans have sought or based their decision-making on, so they would want to hurt Rosenstein so that they could hurt the Mueller investigation. But hopefully saner minds will prevail on the Republican side, and they won't bring this up.
The details within the documents regarding the impeachment of Rod Rosenstein offer cogent insight into the stonewalling Rosenstein and the Department of Justice have engaged in before and after President Trump took office. Soon after Attorney General Jeff Sessions' recusal, the Republicans have been calling for a second special counsel to collect evidence regarding, namely, Hillary Clinton and former President Barack Obama's involvement outside of the Mueller investigation.
If they had spies in my campaign, during my campaign for political purposes, that would be unprecedented in the history of our country. That would be one of the biggest insults that anyone's ever seen, and it would be very illegal. We want to make sure that there weren't. I hope there weren't, frankly.
A second special counsel has been dodged by Deputy AG Rosenstein and Attorney General Jeff Sessions at every turn. And as stated in the resolution, it is evident Deputy Attorney General Rosenstein signed an FBI application to renew FISA surveillance on Carter Page. As such, his conduct in authorizing the FISA surveillance at issue in the joint congressional investigation makes him a fact witness central to the ongoing investigation of potential FISA abuse. Deputy Attorney General Rosenstein's failure to recuse himself in light of this inherent conflict of interest and failure to recommend the appointment of a second special counsel constitute dereliction of duty.
There's a lot of talk about FISA applications, and many people that I see talking about it seem not to recognize what a FISA application. A FISA application is actually a warrant, just like a search warrant. In order to get a FISA search warrant, you need an affidavit signed by a career federal law enforcement officer who swears that the information in the affidavit is true and correct to the best of his knowledge and belief. And that's the way we operate. And if it's wrong, sometimes it is, if you find out there's anything incorrect in there, that person is going to face consequences.
This oversight by Rosenstein, as documented in the resolution, continues to go downhill. Rosenstein refuses to provide all of the documentation surrounding the FISA warrant issued on Carter Page. Rosenstein also failed to notify material fact witnesses by way of congressional request for their testimony. And then there were the redactions. The Department of Justice, under the supervision of Mr. Rosenstein, unnecessarily redacted the price of FBI Deputy Director Andrew McCabe's $70,000 conference table because it was potentially embarrassing information. There was the redaction of Agent Peter Strzok's personal relationship with FISC Judge Rudolph Contreras. Also, the redaction of high-ranking Obama administration officials, such as former White House Chief of Staff Dennis McDonough, and the redaction of high-ranking FBI officials, such as former Deputy Director Andrew McCabe. The DOJ acknowledged the unnecessary redactions and agreed that some of the information should not have been redacted in an April 16, 2018 letter to Representatives Meadows and Jordan. Mr. Rosenstein's memo articulating the scope of the special counsel investigation, which began by noting the following allegations were within the scope of the investigation at the time of your appointment and are within the scope of the order, with nearly everything following the mention of those initial allegations redacted. Mr. Rosenstein's memo is classified and is almost completely redacted, raising concerns the appointment of Robert S. Mueller as special counsel began outside the scope of regulations for special counsel investigations by originating on counterintelligence rather than criminal basis. Despite the significant public interest in the matter and the constitutional authority of Congress to conduct oversight of the DOJ, Mr. Rosenstein has repeatedly failed to provide a less redacted version of the scope memo, even in a classified setting. And then there is the obfuscation of the legitimacy of the Steele dossier done under Rosenstein's watch. The dossier was intentionally transformed into evidence rather than what it really was. A fictional, dirty-dealing, backstabbing, DNC-funded attempt at framing Donald Trump. Rosenstein's impeachment may fall on deaf ears, but he is obviously as crooked as the day is long.
The chair recognizes the gentleman from Texas.
John Bowne reporting.